Welcome to this month's Chatting with Charlie. I'm so excited to be here with my co-presenters today. We got a lot in store for you. As always, our legal disclaimer, we are not giving legal advice. If you'd like some legal advice, give WR Immigration a call, set up a consult so we could give you some. With me today, like I said, I'm so excited for our co-presenters. We have Dan and Kim, new to Chatting with Charlie. Dan is actually our newest face and partner at WR Immigration, specializing in corporate immigration law. Kim is new to Chatting with Charlie, although not new to WR Immigration. She is our I-9 expert, and we've brought her in today because so many of you on the call submitted questions about what's new with I-9. So she'll help us wade through all of your questions and all the updates. And of course, Charlie, with Chatting with Charlie, the former director of visa control at Department of State for over 20 years. He brings his expertise to WR Immigration and to you all here at Chatting with Charlie. I'm Laura Bloniarz. I'm a senior associate with WR Immigration. I specialize in corporate immigration, and I help employers develop, maintain, and defend their corporate immigration programs. Dan, tell us a little bit about yourself. Welcome to Chatting with Charlie.
Well, thanks. I feel really excited to be here. It's almost like I'm on a TV show with the famous Charlie, who I follow closely, as do all of us immigration people. This is my third, I believe, full week here at WR. Super excited to be here, and it's great because I'm sort of reconnecting with people that I've known for ages, like Bernie and Kim from a prior firm, and then a whole bunch of other people from other firms. I'm similarly completely focused on building corporate immigration programs with a sort of super focus on in-house and employee experience, sort of across all sort of sizes and types of employers.
Awesome. Welcome. And Kim, tell us a little bit about yourself.
Yeah, good to see everyone. I am in our San Diego office, enjoying the overcast day here, and I focus primarily on corporate immigration, and then I really geek out on the I-9 issues and the process. And the summer has been completely chock full of the I-9 stuff, so I'm excited to be here and share some information and insight. Thanks, Laura.
And Charlie, we all know Charlie, but do give us a few minutes about your background.
I was chief of the immigrant visa control for 23 years. During the time, over 9 million visas were issued. I had regular consultations with White House and Capitol Hill officials on immigration reform and a variety of issues, providing analysis and my opinions.
Amazing. So we're going to jump into it. Again, we're WR Immigration, and we're helping companies, foreign nationals, on their journey forward. Today, we're going to pick Charlie's brain on his analysis of the October Visa Bulletin to help us plan ahead to know what's in store for the fiscal year 2024. Dan's going to walk us through how to manage an immigrant-friendly corporate program to give us best practices in light of what we're seeing in the Visa Bulletin and benchmarking from his clients. And like we said, Kim is going to walk us through everything we need to know about the Form I-9 updates, and there are a lot. I see we have at least one question on the Q&A. We will hopefully try to tackle those. We do have pre-submitted questions from registrants, so thank you all. If we have time, we'll try to tackle your Q&A, so drop us a question. We'll do our best to answer it at the end of the program. Okay, so USCIS confirmed it will honor Chart B dates for filing. So this is good news. There was some expectation that the administration would radically advance the dates for filing so that many more could file I-485 or their adjustment of status application. But that never happened, despite a bipartisan letter signed by more than 50 congresspersons advocating for this reform. Charlie, I know we talked a little bit about that because there was some speculation of going around because of this letter, could the dates advance for current? And you said that wasn't likely. So as it comes to pass, it's not.
Right.
Can you tell us a little bit about how the Department of State sets the dates for filing?
Sure. When I was chief at state, I would coordinate with USCIS on the determination of the October application filing dates. And we would try to set them, the employment dates and both the family dates, at a point we thought those dates could be reached by the end of the fiscal year. And the reason for that is one of USCIS's policies is that for somebody to use the Chart B application filing dates, a number must be immediately available. That is why they are allowed to be used in the early months of the fiscal year. But once the USCIS determines that the amount of number use through that point in the fiscal year, plus the numbers which are anticipated to be used in the coming months, and the amount of applications that could still be filed based on the use of those application filing dates, if they decide that they cannot allow people to continue using those dates, they will shut it down because they have to have numbers immediately available. So that's why, and plus this year we're in a somewhat interesting issue where the annual limit is likely to be up to 25% lower than last year, meaning there will be far fewer numbers available, and they may, with all the retrogressions which occurred last fiscal year, they may already have a significant amount of demand, quote, in-house. And that's why many of the application filing dates may not have advanced as much as some people would have hoped for, regardless of that bill proposing that they all be made current.
Right. It is such an advantage to be able to file the adjustment of status for a foreign national because of the supplementary benefits of the EAD and advanced parole. So Dan or Kim, if you could chime in here, we're hearing rumors or reading headlines of a pending government shutdown. If I am a foreign national with a priority date that's eligible for filing, what are you advising your clients for October? Are they eligible to still file in light of a government shutdown?
Yeah, Laura, the good thing about USCIS in particular is that it's a fee-based organization. So typically with a government shutdown, USCIS will continue to process their applications and petitions and accept those applications and petitions for adjudication as well. So that's the good news, that individuals can still file their adjustments and they can still be processed during a government shutdown. Dan, what are your thoughts as well?
Yeah, I mean, thankfully, that's not going to be a problem for the USCIS filing, but, general rule of thumb, get it in as early as you possibly can, regardless. Yeah. And I think, did you want to say something about the potential impact with E-Verify, Kim?
Yeah, so unlike USCIS, Department of Labor is not fee-based for a lot of their processes. So for instance, the E-Verify program that is run by USCIS and I'm sorry, get some data from Department of Labor, Social Security Administration, et cetera, different agencies. But E-Verify is affected by a government shutdown. What that means is that employers will not be able to submit cases for new hires during a government shutdown. So all those cases that would normally be opened for initial hires need to be put at bay. And then once the government is reopened, then the E-Verify case will need to be created for those individuals who were hired during the shutdown. The government does understand that with a government shutdown, employers can't comply with the E-Verify requirement. So there is specific guidance from E-Verify that says once you're able to create the cases when the government shutdown ends, then the employer will be able to provide a reason for the late creation of the E-Verify case.
Sounds like a mess.
Yeah.
But the good news is dates for filing, USCIS still accepting applications in light of a pending government shutdown. Let's dive a little deeper into employment-based categories here for all chargeability. So hooray, we've got EB1 back to current. Again, this is final action dates here that we're advising. Charlie can tell us a little bit more about what's going on and what trends he's seeing for all chargeability. Any takeaways from final action here?
I
Charlie?
think it's encouraging that like you said, EB1 went back to current. I think that would probably stay current for the foreseeable future. Any corrective action, they may be able to postpone any need for that till later in the year. I think that the EB2 hopefully will continue to advance, and as well as the EB3, it will continue to advance in the coming months. The only thing I would note is that it's possible that state decided to advance the October dates to a point that they could be held for a period of time, say a month or two, in order to see what the impact of such movements were before they start moving them again. I don't know if they would do that, but it's a possibility given the amount of retrogressions and the volatility they had in dates last year. If they were to hold the dates early in the fiscal year, it's the best time to do it because you then have plenty of time to begin advancing them at a faster pace later in the year and still maximize number.
Yeah, that does sound right because we see, we're tracking here and we saw 2 retrogressions in EB2 last fiscal year and 3 retrogressions in EB3. So remind me, that's pretty unheard of, right?
Yeah, I can't remember there ever being as many retrogressions in a single fiscal year as there were last year, or the fact that there would be multiple retrogressions within the same preference category.
So perhaps there is a more conservative approach. I see just a micro advancement here for EB2 just by a week movement forward in July and pretty moderate movement forward in EB3. Do you think they're taking a more conservative approach in the advancement to avoid future multiple retrogressions?
Yeah, I think so. And I think I think in the Visa Bulletin, they put a note that they were going to adhere to the quarterly limits. The Immigration and Nationality Act says that only 27% of the annual limit should be used in each of the first 3 quarters. The State Department mentioned that figure in the October bulletin. So I think that they are going to take a more conservative approach this year to avoid volatility. Again, the time to do so is at the beginning of the year, while there are more months if they have to increase things at a later point. And especially once they see what the demand is like after they are recovering from the retrogressions which occurred at the end of fiscal 2024, they want to see, are they going to get a huge amount of demand, and if it far exceeds what they were expecting.
Perfect. All right, let's take a look at China here. We see moderate advancements in EB1, moderate advancements EB2 and EB3. Any takeaways for China EB1, 2, 3?
Yeah, I think that China EB1, 2 to 3 weeks of movement per month. EB2 may only advance up to 1 week a month, and EB3 1 to 3 weeks a month. And again, both the India and China movements of the second and third preference, their second and third preference date is going to be largely dependent upon what happens to rest of world second and third preference. As long as there is a rest of world employment second and third preference priority date, that means there are no otherwise unused numbers available, which could potentially flow for China and or India use. And both of those countries have been heavily dependent on such use of numbers in past years. So this year they may be strictly held to their per country limit in those categories.
Good to know. And then wrapping up here, India. We see a good movement forward for EB1 India, albeit still January 2017. So still quite retrogressed in EB1, but we're back into the 2012s for EB2 and EB3. Any insights you can gain from what we're seeing here in October?
Yeah, I think that they may try to do a little bit faster recovery in EB1 initially, and maybe again, as I mentioned in the beginning, they may have want to hold back and not make any moves for another month or two. But if they do go ahead and move, I think that they could move up, up to a couple months in EB1, and then probably hold the date for a while to see the impact. In India's second preference, much of the demand with 2012 priority dates and should have been taken care of in past years. That should allow some movement in that India second preference date. But again, India for the foreseeable future is going to be tied strictly to their per country limit, which is not going to allow significant forward movement of the dates. And the same thing with India third preference. And I would not expect more than a week or so forward movement in the India third, at least in the early part of the year. Again, and I know I'm repeating myself, but the earlier part of the year is when you have the luxury of kind of holding back and then seeing what's happening, and then start to make your moves later in the fiscal year without potentially having the volatility that was experienced at the end of 2022 and throughout 2023.
Okay, so we've been on these calls for almost a year now, and I got to tell you, I still don't understand. We see October 2022, EB2 India was April 2012, and now October 2023, new fiscal year. How come it still hasn't surpassed last year's?
Well, as I mentioned, in past years, both China and India have relied heavily on the availability of otherwise unused numbers from the rest of world category. That changed last year, and that's why in January of 2023, both India first and China first dates were applied to them. And then as we went through the fiscal year by August, and then more, they started running out of numbers, so they had drastic retrogressions. Basically, those August and September dates meant that no Indian first preference applicants were getting visas. And again, this year, India first, second, and third, as well as China first, second, and third, are going to be strictly reliant on their per country limit, which is only going to be in the 3,000 range. And I'll give you an example of how much impact that has. In 2022, India's second preference used over 55,000 numbers. This year, they are facing the possibility of only having approximately 3,000 numbers available for use. So you can see what type of devastating impact that could have on date movements.
Completely. Thanks for that. Okay, and then kind of in big picture summary, we talked before our presentation here to kind of summarize what you're expecting for November. So moderate movements, 2 weeks for EB2, all chargeability, 4 to 5 weeks movement for this is for final action dates, right? This movement that we're expecting.
Yes.
And then I noticed that in the DOS they published they're expecting 165,000 immigrant visas for the fiscal year 2024 limit. Can you tell us a little bit about how to think about that?
I believe that was USCIS published that.
Thank you. Yeah, thanks for the correction.
And I'm a little concerned, a little puzzled by the fact that immigration is projecting a 165,000 annual limit for employment, because that would mean that there were 25,000 unused family numbers. I think that that is extremely puzzling based on the fact that the State Department, for example, in August and September, they held the first preference, family first preference date. They retrogressed the 2A date for April and August. They held the family 2B date for the entire year. The family third date was held for August and September, and they held the family fourth preference date July through 4th. If State Department was concerned that they were not going to reach the annual limits, there is no reason those things should have occurred. They should have been advancing the dates in an attempt to maximize number use. And so it's a little concerning. I'm hoping that that is a mistake on what immigration posted. I have, since last spring, I've been expecting that maybe there might be as many as 10,000 unused, meaning a 150,000 limit. But again, based on what was happening in the family dates at the end of the summer, I thought that that might actually be high, because again, the end of summer family issues indicated that the state had run out of numbers.
Got it. Good to know. Okay, now we're turning over to Dan to help us kind of contextualize all this and give us some best practices from a corporate immigration program, how to manage it as a HR leader, department leader. Take it away, Dan.
Sure thing. So, yeah, I mean, this means longer lines, potential gaps in work authorization, all the sort of unpleasant stuff that you don't want happening to your program. So, unsurprisingly, look at, if you've got a policy on, a certain amount of tenure before someone's eligible for the permanent resident sponsorship process, you might want to look at that again, because certainly plenty of our clients tried, at least in the past, to rely on, especially if you're looking at somebody that's in STEM, that's from all other, to be able to get them to the point where they've potentially got that EAD in hand and don't need to worry about extending being selected in a lottery typically. So that's what you're typically going to see. And given the odds in the H-1B lottery now, that's becoming less and less likely for your population. It always ends up being the ones that didn't actually need it in the end, but that's just how it is. In any case, planning early is important, because you'll get that maximum of 3 years potentially to be able to get to that EAD point. That's becoming more and more of an issue. You look at the length of time prevailing wages are taking, and perms, it's a much longer runway now than it used to be. So that would be one thing I would look at. You want to check in with your counsel regularly on your population. You want to have, however you want to put it, at risk or contingency planning, all that kind of stuff. If you have options to potentially, locate people outside the U.S., without too many, nasty tax implications and stuff like that, you want to look at that and look at the contingency planning on the early side. Given the sort of generally kind of bleak prospects, especially if you're from India or China, look at sort of the holistic kind of impact of your program. You might want to think, well, this is going to be rough, and especially given that some of these folks have been here for upwards of 5-6 years, the cost of continuing to pay for those dependent fees out of pocket really adds up after a while. So give some thought to maybe helping them out on that score on the dependent fee front, of course, weighed with your business needs as well. I would also, and I always say this basically whenever I raise the prospect of green cards, period, is, well, you might, you never know, might be there'd be a surprise advancement at some point. We all kind of remember October 2020 and what happened there. And then in the past, was it 2008? So where they were basically bringing cots into the immigration practices for people to stay overnight. Have your birth certificate and marriage certificate ready, because that's initial evidence. And there's always that sort of scramble when these things happen. Not that, I'm getting super excited that it is likely to happen, but, always a good reminder. We always remind the foreign nationals going through the process, have them at hand, because if there's anything you need, it's going to be those things to be able to file. So we can go to the next slide.
Absolutely.
All right, so just sort of shifting gears a little bit. Again, I'm really excited to be here. a lot of it is because of this, basically the technology. And as part of my kind of search for, where do I want to bring my team, a big part of it was technology. So I kind of had it pitched to me as if I was a client, which I was thinking it makes sense because I'm going to have to do that down the road. And almost disappointingly, you had everything that I wanted on my wish list already because, I enjoy yelling about, hey, why don't we have, LCA posting and management, stuff like that built into our process. And the dashboards, of course, really impressed me as well. Reports, if we want to go to the next slide, take a quick look. So there's your sort of overall dashboard, and I'm getting really excited to be able to mess around with these things myself more. This gives you kind of a quick, this is your population, which you can then drill down into further. And this, of course, is going to be super useful for clients when they're trying to figure out, like, okay, who's going to be impacted by, these priority date retrogressions, potential advancements, stuff like that. We can take a look at the next slide. Right, so this is our Bleak Filing chart again. So of course we, like most other firms, will run reports that as soon as we get the visa bulletin, we'll sort of run cross-reference with priority date and country of chargeability so that we can figure out, okay, who is going to be able to file next month, and then be able to hit them quickly with, okay, here's what you got to do to pull everything together. This is a sample report that kind of shows you, at a high level, okay, here's where they are in the permanent residence process and who is eligible to file adjustment of status, which you can then drill into specific cases as well, which is super helpful. And I can't wait to make use of it myself.
Yeah, and one thing I noticed that happened this year with many of my clients is Chinese foreign nationals or Indian foreign nationals who've been in these backlogs for so long, have a previously approved I-140 and don't necessarily push the green card initiation because they say I have such a long line to wait in. But we saw steady but moderate advancements for Chinese EB2, EB3, and some of those priority dates snuck up on folks where they have now a current priority date, but because perm was taking so long, they're in a rush now to file or get through the perm process. So I think these reports are super helpful in identifying those populations of, yes, they have the I-140 approved, a priority date, but let's start projecting out like it's going to take 2 years to get a new I-140 for their current company. And we want to make sure everybody's in a good position that when their priority date becomes current, they're not waiting on DOL processing. They can just move forward with filing their adjustment of status. So
yeah, I think that goes right along with the whole evaluate your tenure policy, because that population is growing. There's the population of people that have the prior employer locked in priority date. So and yeah, you're totally right. There's a lot of times they don't seem to treat that as much of a priority, even though it could potentially impact their ability to extend their H-1Bs once they do become current. So another reason to sort of look at those and potentially prioritize them.
exactly. Okay, now we're going to shift gears, and Kim's going to take control here and tell us all about what's new with I-9, and it is a lot, right?
Yeah, there's a lot. So I'm going to do sort of a high level and some of the hot topics. So the new version of the Form I-9 is dated August 1st of 2023. It is effective August 1st, but note that companies are not required to use this new form until November 1st. So the current version, which is, I guess we have two current versions. We have the October 2019 version, which will be accepted, meaning that it can be utilized for the I-9 process until Halloween. So October 31st is the last day that the 2019 version of the Form I-9 can be used. And then on All Saints Day, November 1st is kind of how I remember things with this particular date, a holiday or something fun. That is when the new form version of August 1st, 2023 must be utilized by an employer. Where do you know where the version edition is located. It's in the left-hand corner. So you want to make sure that you're using the August 1st, 2023 version as of November 1st. One of the other key things that's really exciting about this Form I-9, I told you I geek out on I-9 stuff, but this version is 1 page. So we're going back to a 1-page Form I-9, which we had many years ago. And in order to do that, the Immigration Service has shrunk the fields. So that isn't necessarily going to be a problem with those who are using electronic I-9 software program, because those fields are going to be right there electronically. But for those employers that are using the paper version of the Form I-9, the fields are small, so you're going to have to write tiny in order to put all the information in, especially if you're completing List A for a foreign national that might require 3 forms of documentation to prove their identity and work authorization. Those are typically your J1 individuals and your F1 individuals who are on CPT. So get used to writing tiny. But this is also exciting in that there is a section, or there's a box now in the additional information field that allows for employers to confirm that they've used the new alternative procedure. And the alternative procedure came about because, I guess this is one of the good things that happened with COVID-19. We had to use remote or virtual completion of the Form I-9 in some instances, and the government, as you all may remember, between March 20th, 2020 and July 31st, 2023, allowed for companies to do a virtual review of the documentation to complete the Form I-9. So given that it actually worked pretty well, and our verification and documentation committee met with the government individuals that were involved in the creation of the new Form I-9 and kind of touted the benefits of a virtual process. So the alternative procedure process came about as a result of negotiations between various government agencies such as ICE, Homeland Security Investigations, which conducts the I-9 audit, and USCIS, which is the entity that actually creates the form, the instructions, the M274 handbook, et cetera. So those are some of the new features. With that, Laura, we can go to the next slide where we'll talk a little bit about the alternative procedure.
Perfect.
And
Question
yeah,
for you though. So this is great content. Why does it take the agency so long to decide that this is where they want to move? Like, I know I had clients really panicking about whether alternate procedure would be something available to them. Why do they wait to the last minute?
well, there were, based on our understanding, a lot of negotiations going on with the various agencies, right? So we were hoping that we could kind of roll from the flexibility, the COVID-19 flexibilities into the alternative procedure. We kind of sort of did. But there's a lot of hesitation on Immigration and Customs Enforcement side, on ICE's side, because of potential fraud with individuals presenting documents that are not valid, right? It's a little bit easier to send a copy of a document and for an employer not to notice that theirs isn't a hologram on that version of the card. So that was some of the concerns from ICE, as well as identity theft being another one, where the employer is not looking at the individual like they normally would with physical inspection. But it did take them a long time to get there. There was the notice and comment period was in August of 2022. So it took them a whole year before they came out with the new version of the form, as well as this new alternative procedure. And this is a compromise, the alternative procedure.
Great. And we had a question here. Will this be recorded? Because they're interested in the I-9 section. Yes, we'll post this on all our socials, on our website. So this is great content. And actually, Kim has a whole series on our website. So this is just a fraction of the information, and she's got other videos posted. And to my understanding, you're going to continue the series given the feedback and interest in I-9.
Yeah, that's correct, as we get more and more information on the new process.
All right, thanks for letting me interrupt you. Please continue.
No, that's not an interruption at all. So if you're, going forward with using the alternative procedure, which allows for virtual review of the documentation that employees are presenting to prove their identity and work authorization, there are some caveats. And this was part of a compromise in the negotiations amongst the agencies. So one of the primary requirements is that the employer must be a qualified employer. And the question is, well, what is a qualified employer? A qualified employer is an employer who is enrolled in E-Verify and it is in good standing. Now, good standing is a term of art somewhat because we don't have definitive confirmation from USCIS of how they define an employer in good standing. We have general information. What we don't know is how that will be implemented. So will an employer receive or have some kind of due process, meaning that they would know in advance where USCIS comes out and says, hey, we noticed that you haven't timely submitted cases for new hires, and therefore we're kind of putting you on probation. You better do this, otherwise you're not going to be in good standing. So basically, to be in good standing, you need to have that signed memorandum agreement with the government. You have to be timely completing the E-Verify cases for new hires. You must be collecting the copies of documents that are required, et cetera, right? So you have to be an E-Verify employer in good standing to participate in the virtual verification process. And like I said, that was one of the compromises so that there is some kind of safety net, so to speak, because with E-Verify, the government is reviewing the documentation that's presented to ensure that the individual's passport is in their database as that is a real U.S. citizen. So then once you are an E-Verify employer in good standing, what do you have to do? You still need to comply with the I-9 process, right? So no later than the end of the first day of employment, the new hire is required to complete Section 2. And then what happens then under this alternative procedure, that new hire needs to send the employer copies of the front and back of the List A or the List B and C documentation that the individual is using in order to confirm their identity and work authorization. Questions have come up about, well, what if the backside is blank? Do we still need the employee to complete or provide us with the back of that? And our recommendation is yes, because you don't know that the backside is blank unless you have a copy of the backside. And to just make your policy consistent, and so that you're not going back and forth with an employee to say, I think there's something on the backside. Well, no, there isn't. Well, yes, there is. Just have everybody provide you with copies of the front and back of the documentation that they're providing.
I think that's a good point that Kim highlights there is with the I-9 and especially around the discussion of documents that someone's providing, you can get into some employment discrimination issues. So our specialty here is immigration, is I-9, but this is where there's some crossover. So as you're developing your policies, you'll want to be checking in with Kim and your employment attorney to make sure your policies are facially non-discriminatory and then executed in a non-discriminatory way.
Right, and that's an excellent point that you bring up, Laura, because the Department of Justice's Immigrant and Employee Rights section oversees the discrimination of the I-9 process, or discrimination in the I-9 process, one of which is document abuse. So as much as you don't want ICE knocking on your door for an I-9 audit, you really don't want IER knocking on your door for an audit of your I-9 process. So once you, as an employer, collect the documentation, you're going to review it, make sure that it appears, reasonably appears to be genuine. Like I said, it's a little bit more difficult with a copy because you can't tell if there's a hologram on there or different other features, but you look at the documents. And then you conduct a live video interaction with the individual. And this has to be within that 3 business day period of time, because remember, you're completing the Form I-9. So by no later than the end of the third business day, which you can think of it as the Thursday rule, if someone starts on a Monday, the end of the third business day is Thursday. So you would conduct the video meeting with your employee who, like they would do in person, they would take their document. I'm going to pretend this is a document. They're going to take their document and put it up to their face, right? And say, here's my passport. So as an employer, you're looking at the document and comparing it to the copy that you have. It's important to note that if the employee between Monday and Wednesday, when they complete section 1 and you have the video meeting, they've lost their passport, which is what they provided a copy to you of, you can't conduct that video meeting. You have to have the employee now present you with alternative documents, and then you can proceed with the video meeting. Once you review the documents with the individual, then you're going to complete section 2. And you'll also want to make sure that you're going to check the box in the additional information section that you are using the alternative procedure in order to complete section 2. Once that's complete, you have to, as an employer, retain copies of the documents that were provided as part of this alternative procedure. And then you finish your I-9 process as you normally would, right? So you're going to retain everything, make sure you have all the information accurate in the form, that you sign and date the form I-9 as you normally would, either the paper version, or if you're using an electronic I-9 program that meets all the criteria. So that's
okay. So this sounds both complex and straightforward and confusing, and it probably a good opportunity. Would you be recommending for HR teams, recruiting teams, whoever's processing I-9 to maybe take a refresher training, work with counsel to outline the workflow so everybody's consistent and accurate with the new process?
Absolutely. You want to have your strategy in place. Employers can still utilize an authorized representative to do this process if you have remote employees. So you want to make sure that you're documenting the steps that your team is going to take in order to complete this process, so that you don't forget a step. And as you mentioned, Laura, you don't want any discrimination issues coming up where you might be treating individuals differently. One instance where you can treat different populations of your employees differently is an employer could adopt a strategy where they're going to do physical in-person review for all those individuals that are coming into a work site, and then only utilize the alternative procedure for individuals that are remote employees. So there's a lot of different things that employers can do with developing their strategy, and they definitely want to have that in place and train the individuals who are going to be implementing this I-9 process to make sure that it is done properly and consistently.
Amazing. A lot to take in there.
Yeah, it is a lot. It gets us confusing sometimes too, right?
And these were summarizing a lot of the questions we received from you all on the line here. So Kim, can you tackle all of these questions?
I will do my best to go through these questions.
Okay.
So these are questions we got from registrants, and they're also questions that I receive throughout the week from individuals, from individual employee representatives. So does the alternative procedure apply to I-9 work authorization re-verifications? So what this means is if you have an individual who's in H-1B status, and you as the employer extend their H-1B status, they're now issued a new I-94 document on the bottom of their I-797 approval notice. And as such, because the individual's work authorization is expiring, in order to continue to employ that individual, you have to complete the re-verification process for the Form I-9, which is now on Supplement B of the Form I-9, right? So it is no longer Section 3. This is the old Section 3. It is now Supplement B. And an employer can use the alternative procedure to complete the re-verification of work authorization as long as the employer was enrolled in E-Verify at the time of the individual's initial hire. So that's the caveat, because again, we're going back to the government wants to make sure that there was some initial protection, which is the E-Verify process. second one is, if we did e-verify and virtual review during the temporary COVID-19 flexibilities, do we need to do it again? Unfortunately, yes. And we had that confirmed multiple times by USCIS. And I know it seems to be redundant, but again, the government wants to make sure that there is the end of COVID-19 flexibilities with the reinspection process, and then this new alternative procedure, or what can also be referred to as optional alternative 1, kicks in. So they wanted to make sure that there was a defining end to the COVID-19 flexibilities with the reinspection. So unfortunately, if you did pretty much what the alternative procedure is between March 2020 and July 2023, you do have to do it again to fulfill your completion and reinspection of the COVID-19 flexibility provision. The former I-9 had drop downs in the fields. Is that expected in the August 1st, 2020 version? The only drop down field that's there right now is for the states. This is the form that the government has published. It might take, additional comments to publish something a little bit differently with drop down fields, but as of now, we don't know of any intention to include those drop-down fields. What is the best way to complete the I-9 process for remote employees? This is a very common question, because now we know, right, especially down with working on the corporate programs, people are all over the country, right? They're working in all different states. So you may utilize the use of an authorized representative. So an authorized representative is someone who is taking on the place of the company representative to review the documentation and complete section 2. There's a lot of guidelines that you want to have with authorized representatives, because as an employer, you still retain that liability for completion of the Form I-9. And we could do like a 25-minute discussion on the use of alternative reps, how to utilize them. One, USCIS as an authorized rep may be any individual, family member, friend, etc. Just noting California, if an authorized rep is receiving compensation to complete the Form I-9 on behalf of the employer, then that authorized rep must be an attorney, a bonded immigration consultant. If the individual is not receiving compensation, then it can be a family or friend. And then the use of a notary in California is strictly limited to only those notaries who are bonded as immigration consultants. So in California, be very careful about the use of authorized reps so you don't step into bad things. And let's see, with the new alternative procedure, our company is required to keep physical files. Again, that depends on what your process is. Do you keep your I-9s electronically or paper versions? So you want to make sure that you work with your counsel to have a definitive strategy for how you're going to retain documents to make sure that they're in compliance with the government's regulations. And then last, if we have not finished the reinspection process for the end of temporary COVID-19 flexibilities, what does that mean? I'm just going to end this with a quote from DHS press release that was July 21st. They stated, if an employer is otherwise compliant with the law and regulation and had followed the COVID-19 flexibility guidance, U.S. Customs, Immigration and Customs Enforcement will generally not focus its limited enforcement resources on Form I-9 verification violations for failing to complete physical document examination by August 30th, 2023, particularly where the employer can show that it has taken timely steps to complete physical document examination within a reasonable period of time. So what does that mean? It means if you didn't complete it by August 30th, keep on going, keep on chugging along, get those re-inspections completed so that you are not found to not have a valid I-9 in place for that individual, which has hefty penalties.
Awesome. That was a ton. There's going to be more content coming from Kim, so stay tuned. Sign up for WR Immigration Updates so you can keep getting this good content, because there's a ton to work through and it is very confusing.
Especially for a one-page form, right?
So now back to Charlie, just to kind of summarize observations and expectations for family-based fiscal year 2024. Charlie, what you got for us? You're on mute.
Sorry about that.
No problem.
I think that the, dates will start to advance for family on the rest of the world. I think that there should be movement in the F2A and maybe a little bit faster forward movement, but I would expect, steady forward movement of up to several weeks in most of the family preference for rest of world.
We've got one question here. How about the F3 cases movement through 2024? Any thoughts on F3?
Family third, I would say, I saw several questions relating to this in the thread. If you look at the application filing dates, assume that is where the final action date will be by September. That is always kind of a good rule of thumb. So if your priority date is not within the application filing date, which is listed, it is unlikely that you'll be processed during fiscal 2024. There may be changes to the application filing dates during the course of the year if they are not receiving enough filings as they had anticipated. But again, watch those dates for, to project when your case may become available.
Sounds good. Okay, we've got more questions from registrants, from the registration. So thanks for submitting them. We'll tackle these, and then if we have time in the last 8 minutes here, we will take more FAQ from the chat line. So thanks for submitting them. We'll do our best to get to you guys after we work our way through these questions. So the first one here is part Charlie, part Dan or Kim. EB2 or EB3 India, will the final action date move to December 2013 in the near future? How many years will it take final action date to reach December 2013? So first part is for Charlie about what are we expecting for EB2, EB3 India? Do you think it reaches 2013 this year?
I do not believe it will, based on current indications. I think that we'll be lucky to get beyond about mid-2012.
And then the question about EB2 or EB3, this is one when we see EB3 have a more favorable priority date, whether that be in final action or in dates for filing. Dan, how are you advising clients who qualify for EB2 but see the better advancement in EB3? What are you advising your clients?
This really varies a lot in terms of, the client's overall program, similar to what we were talking about before. If you're looking to sort of, have a more kind of employee-friendly program, you will, consider, especially if it's a significant advancement, so-called double dipping on the same labor certification where you file that, the petition in the category that is favorable now, or a downgrade, or what we also would later call a re-upgrade after they flipped again. It's kind of sad. You do this for long enough, you start to see the flip-flops in the advantages. And then the one thing I would flag is that later on, when there's yet another flip-flop, the mechanism for letting CIS know that, like, hey, I'm current now under, EB2, but my last approved I-140 was an EB3, and maybe they've got an AOS pending too. So how do the mechanism for letting immigration know that is not great. And
Right.
it can be really frustrating because they won't necessarily, give you any kind of recognition that you did that. There used to be a mechanism for doing that. I think it was called Streamline or something like that, where you could actually ping somebody at the service center a specific inbox. But I think they deactivated that last time I tried. Pretty sure I got a bounce back on that. Anyway.
So it sounds like, meeting with counsel to advise specifically on the benefits, do a cost analysis, and largely will the employer support it from a filing perspective?
Right. Yeah.
Okay, great. Next question again for Charlie. How will EB1 final action date proceed in fiscal year 24? So I think just sort of general insights on EB1, Charlie. What do you got?
I think like I said earlier, rest of world, I think it can stay current for the foreseeable future. State will look at the EB1 rest of world number use, and they should be able to determine by mid-year or late spring if there are going to be otherwise unused numbers, and then they may be able to start providing those numbers for potential use by Chinese and Indian employment first preference applicants. But it's important to remember that whenever there are, quote, otherwise unused numbers under the annual limit, they are made available strictly in priority date order without regard to the country. So since the Indian applicants in the employment first preference and the employment second preference typically have the earliest priority dates, usually most of the unused numbers go to India and China, to India employment first and second preference applicants.
Thanks for that. Okay, I think we're someone's giving you some homework, Charlie. Charlie, could you analyze the number of EB1 I140 approvals in fiscal year 2022 and fiscal year 2023 released by USCIS to predict future China EB1 Visa Bulletin movement? Is that how that works? Like the number of I140 approvals dictating EB1 movement, or how does that work?
Not really, because the fact that you're more concerned with the amount of cases that are ready to be processed in the next few months. The mere fact that the case was approved, the petition was approved, it still has to go through many hurdles before it gets to the point where a number would be used. So you don't want to be, at least on state side, in controlling number use, you don't want to be overly concerned with petition numbers versus how many people are actually ready to go at any given point. You would keep it in the back of your mind, but you have to know that, okay, if 100 petitions were approved today, those petitions may not be ready for processing until next summer sometime or the next fiscal year. So why consider them at this point?
Fair enough. Okay, do we anticipate Philippines EB3 dates to remain consistent with worldwide, or do we think there should be more worldwide slots?
I think that for the foreseeable future, Philippines third may stay at the worldwide date. The reason being that any unused Philippine fourth or fifth preference numbers can fall up to Philippine employment first, and any unused Philippine first and second preference numbers can fall down to employment third. And that has typically been the case, providing a very large amount of numbers available for Philippines third preference. And so unless there is a huge backlog of Philippine third preference cases, I think for the foreseeable future, Philippines third will stay at worldwide date.
Okay, I think that's positive news. I'll take that as a positive. We'll take that as a win.
Yes.
Okay, so now we've got this next question, which I think is a little vague. So if this registrant is on the line, please clarify. This one is leaving and returning to the U.S. while on visa to work in the U.S. What is expedited processing and how does it work? I think there's some interpretation here that we're going to have to sort of have Dan or Kim fill in the blanks to try to respond unless we hear from the submitter here. Okay, we'll give them a few minutes to respond. We'll jump to the next one. When is it right to apply for a visa in a third country? So this is talking about when a foreign national goes to a country that is not their country of birth or citizenship to process their visa. Dan, any thoughts on this?
Yeah, so especially with some consulates still experiencing some fairly lengthy delays, and with the holiday season kind of terrifyingly not that far away, and the sort of resulting slowdowns that you occasionally see there, third country processing can be a good option, and most of the time it works if you can get the appointment. That's an if you can get the appointment, of course, and it sort of also depends on an analysis of the factors. Where is the foreign national from? Do they have a tie potentially to wherever it is the third country is that they are looking to apply. Are they looking at Canada or Mexico? Is there any availability currently? So there are a number of factors on that score. The other important factor is their visa currently still valid? So do they have a means to potentially get back in should it, the unlikely event of their visa not being issued come about? Administrative processing, I think, as most people have noticed, is way down. So that's probably less likely than it would have been to be a red flag that I'd throw out for a situation like this. But it is sort of, a multi kind of, we want to look at the specifics of that applicant's situation. Again, especially, do they have any validity left on the visa? Can they take advantage of the 30-day rule? Well, they can't if they go up and the visa has expired. They can't use automatic revalidations or temporary 30-day or less trip to Canada or Mexico.
Thanks for that. We're at time. We went a little bit over. Thanks for answering that. Join us next month for Chatting with Charlie on October 25th, 11 a.m. Pacific. We'll have another crew of WR Immigration presenters along with Charlie. Submit your registration and questions early. We weren't able to get to everybody who submitted a Q&A in the chat line, but do register and submit your questions so we can take it live next month, October 25th. Thank you all.
Thank you.